So in this video, we're going to look at the type of jurisdiction known as territorial jurisdiction. What exactly is that? Well, it's the application of a system of laws made by a sovereign over a territory and enforceable in that territory. The sovereign in international law is not necessarily a king or a monarch, but the head of state of that territory. The word sovereign here is rarely in reference to the sovereignty of that territory or state. Now, in democracies, the power to make laws to apply to a particular jurisdiction will not usually lie with the sovereign, but instead with the legislature. So in the UK, we have the legislature, the executive, and the judiciary, and these are three branches of government. The legislature, which is Parliament, of course, in the UK, makes the laws. The government executes or carries out the laws, and the judiciary tries cases involving those laws. Now, you will have heard the expression UK law, but in reality, the UK is not one jurisdiction, but three jurisdictions: England and Wales, which is one jurisdiction even though it is two countries, and Scotland and Northern Ireland. Some laws made in the British Parliament apply only to England and Wales, some to England and Wales and Northern Ireland, and some to all of the UK. Bear in mind, of course, that the devolved countries have their own legislatures, which also, of course, being legislatures, make laws. So let's see this phenomenon of territorial jurisdiction in action. Let's look at the Criminal Justice Act of 2003, and you will see that Section 1 applies only to England and Wales, which together form a single jurisdiction. So that's Section 1, England and Wales only. Moving through the Act, we see that Section 36 applies to England and Wales and Northern Ireland, but not to Scotland. And finally, we see that Section 46 applies to all of the UK, including Scotland. Now, if you look at Section 36, this does not apply to Scotland because Scotland has slightly different criminal disclosure rules from England and Wales, while Northern Ireland has the same rules as far as the Criminal Justice Act 2003 is concerned as England and Wales. Looking at Section 46, which applies to the UK, this is to do with jury tampering. Well, of course, jury tampering is unacceptable in any jurisdiction, and it is no surprise that the whole of the UK would be of one mind as far as the need to discharge a jury if jury tampering is suspected. Now, some acts will apply exclusively to one or two jurisdictions. For example, the Wills Act of 1837, this act applies to England and Wales and Northern Ireland. Scotland is not included. Let's look at another act. Supposing we look at PACE 1984, the Police and Criminal Evidence Act. Now, considerable sections of this act apply to the UK as a whole, and some parts also apply to just England and Wales. But you will occasionally see that some parts apply to England and Wales and Scotland, but not to Northern Ireland. So the point is, if your client is being, let us say, threatened with legal action or criminal prosecution, you need to find the Act of Parliament, statutory instrument, or even local bylaw that is referred to, that is relevant to his case, and then check whether that law or bylaw has application in the territory where the offence or breach is said to have occurred. If your client is in Scotland, for example, then as we saw earlier, Section 36 of the Criminal Justice Act will not apply to him. So there are many examples of territorial jurisdiction in which we can look at in this way.